everybody. I think we're more or less ready to start. Welcome. Great to have so many of you in the room. I'm Kara Horowitz. I'm the co-executive director of our Emmett Institute on Climate Change and the Environment here at the law school, which, as many of you know, works to find climate solutions from a law and policy perspective. So I'm thrilled to have with us today Vic Sher of Sher Edling. He has had an unparalleled career using the courtroom to protect people and the planet. He's one of the most successful environmental litigators around, so I love having him here at the law school to talk with us about his career and in particular some of his most recent case filings. A little bit on Vic's background. He spent more than 10 years with the environmental nonprofit Earth Justice. Back then it was called the Sierra Club Legal Defense Fund, including 3 years as its president. And during that time, he pioneered litigation strategies for the protection of natural resources. He's been a firm lawyer for many years, and as a firm lawyer, he often represents nonprofits, municipalities, and communities fighting for environmental protection. One of his most high-profile cases was representing New York City as lead trial counsel, winning a verdict of over $100 million for the city. For MTBE contamination in the neighborhood of Queens, which happens to be my mother's old neighborhood. So
my mother's too.
Thank you very much for that work, Vic. My family thanks you. He's now turned his attention to the problem of climate change. He's the lead lawyer on a set of recently filed high-profile lawsuits that have generated a ton of attention in climate policy circles for their creative use of California state law and in particular California common law to tackle climate change harms. There's been so much in the news recently between the hurricanes and the fires about the damage that communities have suffered and are continuing to suffer because of events that are tied or at least maybe made worse by climate change. And so Vic and his team are trying to answer a very important question, which is, to what extent can communities hold fossil fuel companies and other defendants liable for the damage that comes from those harms? So he's going to tell us a lot more about that effort. I'm really thrilled to have him. Thank you so much, Vic.
Thanks. Thank you. It's great to be back at UCLA. So we have filed, as of today, 3 lawsuits, 2 on behalf of counties. San Mateo County is the most at-risk county in California for sea level rise because it has both an ocean coast and a San Francisco Bay coast. Marin County, which is the number 2 most at-risk county for sea level rise, also having 2 coasts. And the city of Imperial Beach, which is the southernmost town or city in California, largely underserved community of color, and which stands to lose upwards of 1/3 of its surface area to sea level rise in the next few decades. And I want to share with you in the time that I have what has been for me a voyage of discovery that started in a place of extreme skepticism. About 4 years ago, I was talking with a friend of mine who was a member of the Intergovernmental Panel on Climate Change. She has a Nobel Prize, I do not. And we had known each other for decades in various environments. She's a botanist by trade and is an expert on ecological systems. And we had worked together on various things over the years. And she says, you know, Vic, I read in the papers all the time about how climate change is a problem that is going to be hitting us in 50 or 100 years. And she says the truth is that species and communities and industries are dealing with it today. She says, isn't there something the courts can do about it? And I said, I don't think so. Because what I read is that there's no way of attributing particular climate-related events to particular emissions during a particular period by particular corporate actors. And she said, well, you ought to start talking to, and she gave me a big list of people, and I started making phone calls. So there are really a fairly fundamental set of questions that a trial lawyer has to be able to answer in a case like this. And the primary ones, I mean, we'll talk about the legal issues a little bit down the road, but the primary questions are scientific. how robust is your science? And I don't believe in investing time and money and court time and resources in cases that are speculative or before their time or, and this is the bottom line, of course, likely not to succeed. Let me share with you how we went about this. The first step is, how do we link impacts to emissions, or building the causal link between carbon and methane that goes into the air, CO2 and methane that goes into the air, and particular impacts in the real world. Here, let me give you a little bit of context. So this chart, which is from the Global Carbon Project, illustrates historic use of coal, oil, gas, other refers mainly to cement production, and then you have land use change, the light, thin, round line across the top. Here's what's significant about this. Land use change, which means agriculture and deforestation primarily, has been a source of emissions since the mid-1800s. And it's varied over the years, but it's been a fairly constant source of those emissions. And then what you see is really in the post-World War II era, an explosion in the use of coal, oil, and gas. Scientists call this the Great Acceleration, and it really took off in the mid-60s. And remember that date because it's significant for other reasons. Cumulatively today, these non-land use change sources, which are collectively known as industrial uses, so that's the coal, oil, and gas, collectively those are responsible for about 80% of all historic emissions of these gases. And here's a kicker, half of them have occurred since 1988. Half of all of the emissions in history from these sources has occurred since 1988. And the rate of emission annually has increased between 1990 and 2015 by more than 60%. So these time frames are going to be significant when we start talking about things like what companies knew when and what they did about it. For now, the takeaway, and this was the eye-opener for me as I started looking at this stuff, was we're not talking about a problem really that goes back to the dawn of the Industrial Revolution, when nobody knew from global warming or climate change or whatever. We're talking about something that dates back to the Johnson administration. Lyndon Johnson. You guys, I remember. Okay. So the basic conceptual framework, and there are variations depending on what kind of impact you're talking about, but the basic, the entry-level concept for me was something called cumulative carbon. And the notion behind cumulative carbon is quite simple. It's focused mainly, historically, on temperature in the atmosphere. And what this tells you is that if you know how much carbon has been emitted, you can calculate the temperature response. Initially, it was on a global mean basis, but this is not really very helpful because the globe is warming more rapidly at the poles than at the equator, more rapidly over land than over the oceans, and more rapidly in the atmosphere than in the oceans. But it turns out, not only is it not literally instantaneous, but it's virtually instantaneous. The mixing and the temperature response is very rapid in the atmosphere. And it applies locally. That is, if you know a volume of emissions, you can calculate, first of all, you can calculate the global mean temperature change. If you have a measured local temperature change from weather records, thermometers, then, and it is different than the global mean temperature change, you can calculate the contribution of the volume of emissions proportionately. It's the same. So if you have emissions that have caused 20% of the global mean temperature change, they have also caused 20% of the local temperature change. And as one expert put it, this is a simple and powerful link between total global emissions of carbon dioxide and local climate warming. This approach can be used to show how much human emissions are to blame for local changes. So that's temperature in the atmosphere. First step. Ocean temperatures, which are particularly significant for sea level rise, also bear a similar relationship. But let's focus in on sea level rise a little bit more. It turns out it's exactly the same. And this is a quote from an article from last year by a guy named Peter Clark and other experts. Peter was the lead author of the chapter on sea level rise by the in the most recent IPCC Intergovernmental Panel on Climate Change report. Similar to global mean temperature, there's a well-defined relation between cumulative emissions of CO2 and global mean sea level, and it also applies locally. So if you know that your emissions have contributed X inches, which is Y percentage of the global mean sea level change, then those emissions have caused the same X percentage of your locally observed sea level change. This is where I started, when I started understanding this stuff, I started to get kind of excited because, remember, we've got emissions since the 1960s, and we can attribute sea level rise. Now, it's a little bit more complicated than this. I don't want to mislead you in the sense that scientists, there are several different major contributing factors to sea level rise. The major one, and what has caused most of what we observe today, is simply the expansion of the oceans as they warm. They get warmer, they expand, and that causes sea levels to rise. But you also have other factors like the melting of land-based glaciers and the meltings of the polar ice caps. And those things are delayed. They're not on quite the same timeline as atmospheric mixing. So scientists distinguish between observed sea level rise, which is the amount that is measured today, and what they call committed sea level rise. And the way you can think about committed sea level rise is if all emissions were to end now, most of the sea level rise that is now locked into the system has yet to occur. So we measure what we've seen today. We know that that's attributable to historic releases. But even if there were no more, what we've observed today is really a small portion of what's going to hit. Oh, and local sea level rise can be affected by major currents in the oceans, major weather patterns, and things like that. But the basic relationship, and it's mathematical, between the emissions and the sea level rise is constant, and you can calculate it. And experts will testify to that. Well-qualified experts who have done peer-reviewed publications and who are excellent teachers and very persuasive. So the impacts on coastal communities of sea level rise, you can't just think about it as a bathtub rising, because really the most serious impacts are when it happens in conjunction with extreme events. We have big storms and high winds, and those other effects of climate change are to make those kinds of effects more frequent and more severe and longer lasting. But when they happen and you have sea level rise, the result for your communities is roads and infrastructure are flooded and damaged, property damage. In a lot of communities, you've got gravity-driven waste disposal systems that are down near the coast, and as the seas rise, you can have intrusion and cause all kinds of muck. And the burden on communities adds up very quickly into billions with a B dollars. So how do we link emissions to specific corporate emitters? You know, obviously, if you can't tell who's doing it, you have a problem. Well, here we've been working primarily with an expert named Rick Heedy, who's with an outfit called the Climate Accountability Project in Colorado. And Rick published a peer-reviewed article in 2014, which is known in the literature as the Carbon Majors article. It's got a very large, complex name, but it's known as the Carbon Majors. And what Rick did was really incredibly insightful. He took the volume of raw material that is converted into emissions when it's used, as reported by companies in their publicly available documents like their 10Ks. So for example, if you talk about Exxon, Exxon extracts a certain volume of crude oil every year, and it reports that volume in its annual 10K that is public. And then it turns out that there is a generally accepted methodology used by government regulators and the industry itself to calculate the emissions associated with that volume of material. So for example, a given barrel of crude oil, a portion of it, on average, is used to make asphalt. Asphalt is not an emission activity, it's actually a sequestration activity. But the rest of that barrel goes to make fuels and plastics and the whole range of petrochemical products. And there are emission factors that everybody accepts associated with the production of and burning of all of those different product lines. And Rick took that and he just added it up. Now, when Rick and I started talking, his original article went back to, I think, 1850. And maybe it was 1874. And I asked him how many companies that are either U.S. companies or do sufficient business in the United States that we can sue them here would it take to get to 25% of all of the global emissions globally, did I mention that, in the world, between 1965 and 2015. We were having this conversation in 2016. And Rick identified 28 such companies that are, by themselves, using his methodology, responsible for 25% of global CO2 and methane emissions 1965 to 2015. Now, the top 5 of them, you won't be surprised, are big oil companies. Chevron, ExxonMobil, BP, Royal Dutch, and Pemex, which is the national oil company of Mexico. And those 5 by themselves are responsible for more than 13% of the global emissions during that period. Now, let me step back for a second. Why did I choose 25%, and what's the significance of these figures? Well, in order to prevail on a tort claim, a plaintiff has to prove that it's more likely than not that a defendant or a group of defendants were substantial contributors to the injury that the plaintiff has suffered. And I thought that 1 in every 4 tons of carbon emissions during this period, during the Great Acceleration, would unquestionably satisfy the substantiality requirement. There is case law primarily dealing with mine pollution of rivers and lakes, where the contribution is much smaller. You can show a substantial contribution with single-digit percentages. But the other purpose was frankly to be able to say, hey, we've identified 1 in 4 or 1 in 5 of of all the tonnage emitted. So we thought we did pretty well with it. We also have 8 coal companies that are responsible for a little over 4%. Now, Rick's methodology is extremely conservative for 2 important reasons that you have to understand. That is, conservative in the sense that he underestimates the contribution to the emissions problem. The first way it's conservative is he only looks at the raw materials extracted by a particular corporation. So, for example, Exxon refines far more oil to make gasoline and other products than it actually extracts because it buys crude oil from others. So Exxon's contribution to the problem by Rick's methodology understates what they're actually putting into the line of products in the chain of commerce. Conversely, by the way, Valero, which is the nation's largest refiner, doesn't make it onto his radar screen at all because they don't extract any of their own crude oil. They only buy it from others. So that's the first way it's conservative. The other way it's conservative, and I'll talk more about this in a few minutes, is it doesn't take into account the leadership role that companies played in a campaign to deny the connection between fossil fuel activities and impacts on the world. So those 2 ways it's conservative, but it gives us a very mathematically robust, scientifically robust method. Now, when we actually filed, the charts I showed you before showed 28 companies responsible for 25%. When we dug down into the numbers, there were 8 companies that we actually didn't think we could get jurisdiction over in California courts. So we cut it down and we sued 20 parent companies responsible for about 20% of the global emissions. So now this is the part when I was telling this story to my sister-in-law who lives in South Carolina and is not naturally necessarily an environmentalist. But her response to this part of the story was, those mother... All right. So in 1965, I told you to remember that date, in the Lyndon Johnson administration, Presidential Level Science Commission issues a report. One of the appendices addressed the issue of fossil fuel burning and predicted that by the year 2000, the increase in CO2 in the atmosphere will modify the heat balance of the atmosphere to such an extent that marked changes in climate could occur. Now, this was a statement, public, and I should tell you that when I first started looking at this issue, I thought I would be building a case about what they should have known and should have done. So this next slide, in response to this report, which would have been, in other cases, this would have been a notice that you point to, see a reasonable company should have investigated. This is not the next slide, the slide after this. So this was President Johnson actually said this in an address to Congress. Okay, so the American Petroleum Institute, which is the umbrella trade organization for most of the fossil fuel industry and really literally all of the oil and gas industry, commissioned a study by the Stanford Research Institute which reported back to the API in 1968, and these are 2 statements from the conclusion, and they're worth reading. So this is SRI reporting to API on an API commissioned report to respond to the inquiry raised by the Presidential Science Commission. Significant temperature changes are almost certain to occur by the year 2000, and these could bring about climatic change. If it happens, we can expect, among other things, a rise in sea levels and warming of the oceans. It's clear that we are unsure as to what our long-lived pollutants are doing to our environment. However, there seems to be no doubt that the potential damage to our environment could be severe. So this is at the start, still pretty early in the Great Acceleration. So 10 years later, well, let me tell you, we have a window into Exxon because some really, really terrific investigative reporters from Inside Climate News, the LA Times, and the Columbia School of Journalism went to the LBJ library in Austin, Texas, and went through Exxon's corporate archives there. So this is a statement saying that we have technology to remove CO2 from stack gases, but removal would double the cost of power generation, and elsewhere in the document they say we're not going to do it because it's too expensive. This is 1978. Here's another one from 1978. Presentation for Exxon's Corporate Management Committee, 1978. Man has a window of 5 to 10 years before the need for hard decisions regarding changes in energy strategies might become critical. This is not a science report buried obscurely somewhere. This went to the Corporate Management Committee. And then in 1982, once the effects are measurable, they might not be reversible, and little could be done to correct the situation in the short term. Now this is a conclusion from the LA Times story, that as many of the world's major oil companies were joining in effort to stave off regulation, this is one of the killer points. They were investing literally billions of dollars to protect their own infrastructure. So they did stuff like raise the level of their offshore oil platforms to account for sea level rise, made them stronger to account for increased storm severity. They invested in technology to access an Arctic that they knew would be warming and less icebound. Literally billions of dollars. And they profited from it. So 1988, we're now 20 years after the API SRI report, and the Intergovernmental Panel on Climate Change is formed, representing a significant worldwide scientific consensus about the reality of climate change and the role of people in causing it. And the fossil fuel companies start funding what we call AstroTurf organizations. So they're fake grassroots organizations that try and deny, and then one of my favorite Calvin and Hobbes cartoons. So these are some things from the campaign that were set out that Exxon and other companies belong to, and it was called the Informed Council for the Environment, and they ran these in full-page ads in the New York Times. It was a very interesting study that came out just a couple of weeks ago by Naomi Oreskes from Harvard, who wrote the book Merchants of Doubt. If you haven't read it, you should. She describes how the template for industries trying to avoid regulations, starting with tobacco and then secondhand smoke and then hole in the ozone layer and then climate change, is to artificially try to construct scientific doubt and uncertainty and then portray that publicly so that people think it isn't happening. And her most recent study was in response to a challenge from Exxon, which said, you know, look at our body of work. We participated in peer-reviewed scientific articles, and we had our internal reports to the board, and you'll see that we were in agreement with mainstream science. Well, it's true. They examined, Naomi and her colleague examined almost 200 peer-reviewed or internal scientific papers, and they found that, in fact, pretty much they were in accord with mainstream science about the relationship between emissions and impacts. And then, as they say in the article, those papers went into the MIT stacks where they were seen by a few dozen people. And meanwhile, Exxon and Mobil, which is now part of Exxon, were running full-page ads weekly in the New York Times saying a very different story. And she holds them up, she shows timeline, and they lied. They just lied. And the lies reach tens of millions of people. This is an internal memo from Exxon, again, 1988, emphasized the uncertainty in scientific conclusions regarding the potential enhanced greenhouse effect and urge a balanced scientific approach, when in fact the scientific consensus, as evidenced by the IPCC, yes, there are uncertainties, there are areas to fill in, but those all err on the side of we haven't caught all of the effects. These are two statements from the API from 1998, so we're now 10 years later. Victory will be achieved when average citizens understand, recognize uncertainties in climate science, and unless climate change becomes a non-issue, there may be no moment when we can declare victory for our efforts. So we were talking just a little while ago about a public hearing on sea level rise in Santa Barbara recently that was attended it was in a hall large enough to handle hundreds of people. There were 14 people there. And so it's also notable, I think, that in the last presidential election, all of the thousands of hours that the two major candidates spent, 50 minutes on climate change, 5-0. So, you know, it's work. So let me turn now to the elements of the lawsuit, actually. So these are the themes, and these won't be news to you if you've been paying even a little bit of attention. They knew or should have known. We have a direct and substantial nexus between the emissions and the impacts. Alternatives and mitigation steps, I didn't spend a lot of time on it, but there is a lot, even if you grant that there is a role for fossil fuels to play. Much of electrification and power, transportation's a little bit more complicated, but much of it could have been avoided at a cost to the companies. At a cost to the companies. And so there are steps that could have been taken. And as a matter of fact, one of the scariest things I think to look at is how radical reductions in emissions have to be as we move forward in order to try and achieve certain goals like the Paris goals and things like that. And the degree of extreme, how extreme the actions have to be gets more and more radical as you do less for longer. So in other words, as emissions continue unabated, our options to avoid dire effects and the costs of moving to avoid them become much, much higher. And if you think about the knowledge timeline, you know, going back to probably not right at 1965, but at some point during the 70s or 80s, when corporate management was being told we have a window of 5 to 10 years, if steps had been taken at that point, you know, the severity and cost of what we have to do now would have been far less. And then you have the denial conspiracies. These are the themes. Well, how do we translate them into legal claims? So this, our lead legal claim is a public nuisance abatement claim in the name of the people. And we have unabashedly borrowed from the lead paint litigation that was brought against by public entities against the manufacturers of lead paint. And this language is actually from an appellate decision in 2006 saying that the lead paint manufacturers were liable, or could be liable, if this was a pretrial ruling, could be liable if they did these things. Well, concealed the dangers, check. Mounting a campaign against regulation, check. Promoting products for use even though they knew that such a use was hazardous to human beings, check. Engaging in a massive campaign to promote the use of their products, check. And in summary, liability is premised on defendants' promotion for use with knowledge of the hazard that such use would create. Now, the significant thing for me as a litigator is that while there have not yet been successful climate change cases, in large part because the science hasn't allowed us to do the kind of attributional analysis that I've been talking about. This kind of liability on companies at the manufacturer and production level is not new. These quotes are from the lead paint case, but we saw them in, this is a dry cleaning solvent contamination case from 2004, and then this is a preliminary ruling in the MTBE case that I handled. So there's nothing novel about this legal theory. Parenthetical, there was a certain amount of novelty to the remedy that the trial judge imposed, which was $1.5 billion common fund, and that's up on appeal. But in terms of establishing liability for abatement of a nuisance, not new at all. So the other legal theories are negligence, product defect, failure to warn, and for all these others except for the public nuisance claim, the remedy is damages. Damages are measured by what are these agencies, these public entities, going to have to spend to repair damage, mitigate it, and adapt. You have communities talking about what's the term for it? Managed retreat, which is the notion that you're going to give up areas along the coast that people have been living in because sea level rise and storms are going to take it out. Well, other communities are looking to pay for ways to adapt and mitigate, and those are going to be very, very expensive. So the damages would be the costs incurred to date. San Mateo County, for example, has spent on the order of $40 or $50 million already. Costs through trial, which will probably be several years yet. I hope it's not too long. My 11-year-old daughter is already talking about taking over the cases. And then the future costs. The future cost is worth talking about for a moment. And I don't think it's just because to a hammer everything is a nail that I like to talk about the MTBE cases. But the case in Queens that Kara mentioned is, it was an area of Queens. So New York City gets most of its drinking water from upstate. They have a reservoir system that's really one of the miracles of modern water engineering. And they get high quality, very good water that comes down by gravity through big tunnels. So the city has acquired in recent years some wells in Queens because as a backup supply in case of something either happens to the system or frankly in case of a terrorist attack on the water supply. So Exxon, we settled with everybody else before trial, and Exxon took the case to trial, and Exxon said, you know what, you're never going to use these wells, and you're asking for $250 million for a treatment facility that you're never going to build and you're never going to use, and even if you did build it, it's a backup supply, so anything about future costs are speculative and you're not entitled to it. Well, the law doesn't work that way. The law says once you've suffered an injury, which is we had contaminated wells, then we're entitled to recover all of the costs associated with that are reasonably foreseeable. So our burden was that we had to show that it was more likely than not that we would incur those costs. And we had, I thought it was just some wonderful testimony from an engineer, a consultant for the city, not a litigation consultant, but an engineer for the city who said, look, if you're building a backup system, it's like a generator at a hospital. It has to be able to run 24/7. Otherwise, if the power goes out, God forbid, you're stuck. And so the jury awarded us the whole $250 million. Exxon's share was only $110 million of it. That's future costs. So let me spend a moment and then I'll wrap up for questions. challenges outside the courtroom. So, I don't know if any of you have been following this. The attorneys general from New York and Massachusetts have subpoenaed documents from Exxon to investigate whether Exxon committed consumer or investment fraud. And Exxon responded by suing these AGs in the federal district court in Texas, claiming that their First Amendment rights were being violated. And they got the chairman of the House Resources and Technology Committee to issue congressional subpoenas on the theory that there was this conspiracy to stifle public debate about climate change. They're taking the tobacco industry model of denial and of obfuscate and confuse, and the industry front groups are already in place. And so as we enter into this, one of the things that our clients and we have to be prepared for is this kind of public relations assault. And so managing the communication side of things is an extremely important part of prosecuting these cases. And I will tell you, as a lawyer who has been involved in many of these now for decades, I hate to admit, but it has been, we're not experts on this. So one of the biggest mistakes a lawyer can make is to think that they know how to handle the case. We don't. Get experts to work with you. We expect that one of the big, so these are big complex cases. They'll be fought like the end of the world is coming by the defendants. And no case is ever without risk. So these are risky and complex cases, but the courtroom risks are manageable. You know, if I evaluate the science and what little we already know about the paper trail, about what they knew and what they did, this is the kind of story that a trial lawyer loves to tell to a jury. But one of the things that happens when you poke a tiger, anybody remember the Exxon, the tiger in your tank? You poke a tiger in the eye, they run to Congress and get immunity. This was a provision that came within one vote on cloture of passing in the Senate over MTBE. And so you can see that something like that could happen here. Now, what our friends in Congress tell us is that as long as the legislative filibuster survives in the Senate, we're good, as long as they don't try to do this as part of some kind of a budget bill, on which they only need 50 votes. So this is, there are risks in the courtroom, and then there are risks outside the courtroom, and this is a big one. So let me just briefly mention all of the cases that I've been describing, and I fully expect that there will be more on all three of our coasts, right? The East Coast, the West Coast, and the Gulf Coast, probably filed. I think we have set a model, and I think there will be more. But those are not the only kinds of, sea level rise is not the only effect on communities and on workers and on species. And so there aren't any other cases filed yet on that. But I will tell you that the big question for all of them is really going to turn on what the science is. The liability story is going to be the same. And the challenge in any cases that involve other issues is going to be linking emissions by companies to the particular impacts that you're talking about. Some of these impacts are well known and well documented already. Ocean acidification, which is destroying shellfish industries. Warming ocean temperatures, which are affecting all sorts of different fish stocks. And heat-related effects. I had one expert tell me that the causal connection between rising temperatures and public health expenses is very, very well documented and tragic because people die in extreme temperatures. Happy to take some questions.
Thank you.
One issue that you didn't talk about, but it's in the news a lot, is the damage to future generations. So I have a former student who's working for the My Children's Trust, and they have this lawsuit where they stayed in court because they're talking about standing for injuries to future generations. What do you think about those kinds of lawsuits, and what are their prospects for success?
Well, the optics of that lawsuit are hugely compelling. You've got, when it was filed, they were young children, now some of them are young adults, and it's taking on claim that the legal theory underlying this case is that the federal government has a public trust obligation to protect future generations against harm, and that the government, not these companies, knew about the problem and should have done more to regulate it earlier. I think it's, so the thing I struggle with in that case is the following, which has basically been the fate of public trust doctrine cases in water and in coastal resources and in wildlife, which is there's a case that establishes the duty that for whatever reason is fought by the trustee. And then you win that case, and then trustees have enormous latitude in how they manage a resource. And so turning it into concrete, enforceable future obligations, and maybe the way to think about it is that if we establish the duty, then we'll deal with, how we manage it down the road. Very creative case.
That's their argument.
Very creative. Yes.
I just wonder if you haven't missed the point entirely. The problem of this carbon pollution is not the basic problem. The problem is human pollution, population change, and you haven't thought of that. And until you control population, you'll be able to do nothing about climate. That's where you have to start.
So
I think the human will take care of it. We'll probably throw a few bombs, and we're going to kill a lot of people and start again, saying we'll never be good. But that's where you've got to start. Nothing else is going to change.
Okay. I don't argue with you about the pressures of growing population and how many problems that causes. One of the things that we will prove in this lawsuit is that there were steps that could and should have been taken to mitigate the problem that we're dealing with, even with as many people as we have. And the rest of us are, I hope that we're not going to be looking at bombs or disease vectors or starvation or any of the other things that could be coming from the population problem. Sometimes you have to pick your fights.
Support Planned Parenthood.
Yes.
So I think one of the critiques of the case that I've seen is that it goes to the direct nexus, which is that it's not just that they're directly putting it in the air, but people have to put it in cars and things first. And I can imagine that your response is, well, so what? People have to smoke cigarettes, people have to eat lead paint. What's the response back to that?
Yeah, so this is the notion that we're actually all responsible because we drive cars, and I took an airplane down to talk with you today. And the reality is that we have things that people have things that they have to do. The liability, though, here is focused on this campaign of deception and the elimination of alternatives that would have made the problem less. And it's a matter of knowledge and choice. We really don't have choices as individuals about whether or not we have to ride in cars. We have to get places. That's what people do. Choices about the nature of fuels and the promotion of these fossil fuels over all kinds of consequences, and the active denial even of the connection between the activity and the effect. That's the basis for the liability, just as in lead paint. And I think actually the tobacco litigations, Lead paint is a little different, you know. The danger was that kids would eat it, but kids aren't making a choice. You know, it's like, it's there and they eat it. Tobacco, though, you had the addiction problem, and the company said, well, you know, people choose to smoke. We don't make them do that. But that's not true, because nicotine was addictive, and in a very real sense, we've become addicted to these fossil fuels.
On that case you mentioned, $250 million case you won.
Yeah.
How successful was that in changing, altering the behavior?
Well, good question. So that was not the first of those cases. The first case was one that I helped try for the South Tahoe Public Utility District. And when we won that case, which was in 2002, in 2003 there were hundreds of cases filed around the country. And right away, I mean, like almost literally overnight, MTBE was out of gas. That was just the end of it. And then the liability story, so you can look at it in terms of driving change. It was the threat of very large financial liability that inspired corporate change faster than regulation could happen. When I'm in a happy place and I think about, you know, how these cases could go, when we get traction in the cases, you know, when we survive the motions to dismiss, when we survive the motions for summary judgment, or when we win the first trial, I think we're going to see some significant change. There's nothing that drives technological innovation of this sort, you know, where the issue is kind of grasping to an old way of doing things, like the prospect of very, very large financial liability.
So a couple questions is really interesting. So one question is, just as a lawyer, can you talk a little bit about how do you finance this? How many lawyers do you have working on the case? What do you have to do in terms of experts? You have a lot of your expertise actually already in peer-reviewed journals, but it can't be all with things like damages, et cetera. Now the other question is just a follow-up to Maya's question. So she talked about the end user, but what about the in-between? What about the intermediate? So these are the extractors, but they're not the gasoline refiners, et cetera. Does that cause you causation issues? Why choose the extractors as opposed to the sellers of the products?
Well, and in fact, so let me take the easiest one first, which is experts. One of the things that's really struck me about the experts in this case is that, at least so far, most of them on the complicated stuff, the stuff I've been talking about, are not willing to be paid. I mean, there will be expenses associated with preparing them and then defending them in depositions and at trial and stuff, but frequently in cases that are about products and defects in products, the major cost driver is the experts, and this will be much smaller for that reason. Next in order of difficulty, I think, is the issue of the mid-level suppliers. And some of the earlier companies, for example, the AEP case, focused on major power companies, and Kivalina as well. And we've gone after the extractors. And we did that for two reasons. One is Heavy's analysis made that possible. The second thing is, well, I guess three reasons. The second thing is, if you were limited, if you looked at, for example, the U.S. power industry, coal-burning power plants, for example, you would be limited in terms of your contribution to the problem globally to their emissions. I think now four, okay? Third, if you view this as a problem of regulating emissions, especially from stationary sources like power plants, but also arguably as a matter of car efficiency, vehicle efficiency, you run smack dab into an issue of federal preemption. And we really didn't want to be dealing with this in terms of the limitations of the Federal Clean Air Act. And then the final thing is, if you look at who led the campaign of deception, it was these guys. The others participated at various levels, but the ones who were funding and promoting these coalitions were the Exxons of the world, less so the power companies. Yes?
What is your opinion on how attorneys at law firms can utilize pro bono to be productive in similar matters?
Yeah, notice how I avoided the question about funding. Yeah, so let me answer that first, and then I'll come back to the pro bono question. We're in a fortunate position of, to a certain extent, having won prior cases and having a caseload that involves other cases that will enable us to do that. We have really great relationships with public counsel that are devoting staff attorneys to help with it. More important, I think, if you look at the arc of a lawsuit, there are different staffing needs at different times. And the early stages, which is what we're in now, is all legal research and writing. It's all motions practice. We're engaged now in a huge motion to get out of federal court and back into state court, and that's briefing. And then there will be briefing on challenges to the complaints, and then we'll get into it. When you get into discovery, you need more bodies. A lot of them are non-legal, though. You need people to review documents and prepare witnesses for depositions. Paralegals are much more important. And we have additional sources of funding. Let me say a word about pro bono work, too, because I get asked that quite a lot. I think pro bono work is a terrific thing for both the lawyer who gets a chance to work on something that is really a passion, and for clients who can't otherwise pay for legal services. I think lawyers, especially young lawyers, have to be very careful not to get in over their heads, because a lawsuit can go, lawsuits, one of the best things a young lawyer can do is have a sense of how little he or she knows. Seriously, so that I cannot tell you how many landmines are out there, whether it's procedural and substantive or tricks of the trade in dealing with judges and juries or whatever. So I think that if you're looking really at, if the question is pro bono in the context of a big firm, that's great, because you'll have the firm resources to support you. If it's pro bono in the sense of you're hanging out a shingle to try and practice law on your own, be careful. And one of the ways of gauging that is to run it by more senior lawyers and get their take on how the case can be managed and might be okay. Yes?
You alluded to the jurisdictional problems. We had a federal court versus state court. Where did you initially file, and what court are you in now, and what's the advantages or disadvantages, state versus federal, on this kind of litigation?
Yeah, so we filed in state court, and we've been removed to the Northern District of California.
Why did you file in state?
Why?
Why?
Well, a combination of reasons. We thought that state court judges dealing with state laws and state court juries would be the best place to deal with these. We've only raised state court claims. As a trial lawyer, there's a very practical reason to prefer state court over federal court that's no secret. In California state court, you have a non-unanimous jury requirement in civil cases. So you can lose 3 jurors and still win your case. In addition, whereas in federal court, it's 8 out of 8. So in addition, if you look at where the fear is on appeal. And granting that at some point the defendants are going to try to get something in front of the U.S. Supreme Court, which these days is not the best place for plaintiffs to be. We would rather have 2 layers of state court appeal before the U.S. Supreme Court in order to A, minimize the number of even arguably federal issues, and B, develop the factual record. Because if an appellate court dealing with a developed factual record is a much better position than dealing with a matter of just pleadings. So, right or wrong, that's what we did. Yes.
So you talked a lot about having a PR campaign in addition to having lawsuits. And I guess I was just wondering how you should brand that campaign, because I hear a lot of talk about, when we talk about climate change, to regular people, to not really talk about it in scientific terms, but talk about it in national security terms and damages to their property, and bring climate change to them. So I guess, how do you combat the negative PR campaign? Like, what would you suggest?
Yeah. So let me first be careful about terminology here. Most law firms, when they talk about PR or communications, it's based on getting publicity to get more clients. Okay? And that's not what we're doing. Instead, our communication strategy has two foci. The first is to make sure that our clients are branded and on message, both in terms of the broader message to the media and the community, but also in terms of making sure that there's no adverse impact on the case. Because you'd be amazed at how easy it is for a client, whether it's an elected official or a private client, to put their foot in their mouth, and how hard it then is for you to get it out of there. So that's the first piece. Now, what I think you were really getting at was the second piece, which is, for us, laser focused on avoiding Congress taking away the right to sue. And that is part of, I mean, if you look at the media rollout for the cases that we filed so far, it's been amazing. It's been terrific. Stories in the New York Times, the Washington Post, NPR, scholarly pieces commenting on the strength of this case compared to past cases. And I will tell you that while we didn't write any of those stories, it's not just by happenstance. And a lot of work goes into it by very smart people. The relating point to this is, when we talk about the bigger political battle over this, and ultimately over our continued right to pursue the lawsuits, it matters very much who the voices are that are being raised in our defense. And I spent, as Kara mentioned, I spent more than a decade in the nonprofit community, and they are, love it, and they're terrific, and I support them, and they will come out on the right side of this, for sure. But they're not the voices that are going to sway the votes in DC. So, League of Cities, League of Mayors, League of Counties, and these are the kinds of voices. If any industries sue, the workers and their trade associations, those are the voices. The people. If we make this a taxpayer and an injured industry against another industry that lied and made zillions of dollars, then we're okay.
I think we have to leave it there. Thank you so much for joining us.